Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to Our Curious Amalgam. I'm Jaclyn Phillips, and the title of today's episode is Can Competition and Quality Coincide? Analyzing a systematic competition law approach to healthcare and quality concerns. Healthcare is an area that many people find perplexing and hard to navigate. When we add competition law to the mix, the discussion becomes even more nuanced and complex. A crucial aspect of this discussion is the role of choice and competition in healthcare. Whether choice and competition should play a role, and if they do, whether choice and competition negatively impact healthcare quality. On today's episode, we speak to Professor Theodosia Stavroulaki, whose new book, Healthcare Quality Concerns and Competition Law, A Systematic Approach, examines the application of competition law to healthcare systems. Professor Stavroulaki's research and today's episode will help our listeners understand the role of competition and quality in healthcare markets as we look at three key questions. 1, what competition issues arise when the pursuit of competition may clash with the pursuit of healthcare quality? 2, must competition authorities balance the goals of choice competition against dimensions of healthcare quality? And 3, how should they balance these goals? Joining me today is my co-host, Jeny Maier. Hi, Jeny.
Hey, Jaclyn. Great to be here.
Would you mind introducing our guest and kicking off today's conversation?
Absolutely. I'd be happy to. So our guest today is Professor Theodosia Stavroulaki. Professor Stavroulaki is an assistant professor of law at Gonzaga University School of Law. Her teaching and research interests include antitrust, health law, and law and inequality. Professor Stavroulaki's forthcoming book, which we'll be talking to her about today, explores how healthcare quality concerns are considered by competition authorities on both sides of the Atlantic. Welcome to Our Curious Amalgam, Professor Stavroulaki.
Thank you so much. It's really great to be here.
Well, we're glad to have you here today. And perhaps to start off our conversation, could you give us a short overview of what is it really about competition and the healthcare industry that inspired you to write this book?
I think that one of the things that truly inspires my work on healthcare antitrust is that although more and more healthcare markets are forming around the globe, the role of competition in healthcare is still a hotly debated topic. In fact, as explained in my book, some consider competition in healthcare anathema and others a magic bullet. For instance, while proponents of the introduction of competition forces in healthcare say that increased competition among providers will improve the quality, efficiency, and effectiveness of the system, critiques of the introduction of market force in healthcare tell a completely different story. Specifically, they warn that healthcare markets are pervaded by numerous market failures, such as negative externalities and information asymmetries, and that neither economic theory nor empirical research offer actually an ambiguous prediction as to the impact of increased competition on quality. Hence, from their perspective, introducing competition in healthcare may harm the performance of the health system at a macro level and the social goals a health system generally strives to pursue, such as equity and access. So, by examining how healthcare markets work and what their limits are, my book aims to demonstrate that the risk that the introduction of market forces in the healthcare system may actually harm some objectives of a health system, such as equity. And I would like to give an example. So, for example, when competition among hospitals is introduced, governments often publish some quality indicators that offer patients, physicians, health insurers to have more detailed information about hospitals' performance and the quality of the services they provide. In the United States, for example, the Agency for Healthcare Research and Quality published this quality information. However, the issue is that because hospitals want to compete and they want to improve on these quality indicators, they might have incentives to game the system. For example, they may have the incentives to try to avoid high-risk patients so that they will improve their performance indicators. And this, of course, critics say that might create some important equity concerns. So the main goal of my book is actually to identify the primary competition problems that may raise when conflicts between the pursuit of competition and the pursuit of quality or access may actually emerge, and so that competition authorities may actually be enabled to address and carefully examine these problems if they did not address a fundamental question first, which is, how should we define quality?
All right. Well, that's actually a wonderful question. From your perspective, then, how do you define healthcare quality for your book's purpose?
The main goal of my work actually is to address how competition authorities around the globe address the notion of healthcare quality when they apply competition on healthcare. And to achieve this goal, I actually examined the notion of quality from an antitrust medicine and health policy perspective. And my book demonstrates that this question, how should we define quality when we apply competition on healthcare, albeit crucial, is far from easy to address. And this is mainly because the notion of quality from an antitrust perspective and the notion of quality from a health policy perspective do not necessarily align. So while from an antitrust perspective, quality is mainly defined as choice, variety, and innovation, from a health policy perspective, quality is actually a multidimensional notion that encompasses also some non-economic goals, such as access, equity, continuity, safety, and the notion of acceptability, or else the notion of trust in the doctor-patient relationship. Importantly, however, the antitrust scholarship claims that the pursuit of public policy objectives, such as equity, should not become part of the antitrust agenda. So, by examining this scholarship with a critical eye, I ask, should competition authorities transform the notion of quality in care when they apply competition law in healthcare so that they take into account the social objectives of the health system, such as equity? And my main thesis is that if competition authorities around the globe define quality in healthcare as it defined in every other sectors of the economy, such as variety and innovation, they risk applying antitrust law in a way that disregards the main objectives of the systems. And I would like to give an example. So, for instance, research in public health shows that poverty damages health. Specifically, it shows that childhood asthma incidence is rising in poor neighborhoods and that the severity is much greater among poor children. In light of this research, I asked, should competition authorities, for example, clear a hospital merger, although it leads to market power in the respiratory services market, on the basis it may allow the merged entity to employ the most reputable respiratory specialists and therefore contribute to the reduction of health disparity in childhood asthma? Should they take into account the notions of access and equity and balance these goals against the harm to competition? So my main thesis is that if competition authorities define quality as it defined in other sectors, goals of access and equity may not necessarily enter their merger analysis. If, however, they adopt a wider definition of quality that also takes into consideration core objectives of the health systems, such as access, then the antitrust enforcers may widen the analysis. And this is because their competition assessment would also consider how a specific agreement or merger may also impact the core objectives of the health systems.
Very interesting. Yeah, it's, interesting idea that there's friction between pursuing competition and pursuing these specific aspects of healthcare quality, namely access and equity. In your book, you characterize the United States as following what you call the market approach to trying to resolve these kind of conflicts. How would you describe the market approach that the U.S. agencies take, and how has that played out in the U.S. agencies' enforcement in the healthcare and hospital markets?
Indeed, one of the key questions that my book seeks to explore is how competition authorities define quality in healthcare when they apply antitrust law in the healthcare sector. And I try to answer this question by studying and analyzing numerous merger and Section 1 cases of the Sherman Act, especially in hostile medical markets. And by doing so, my book identifies the three different models under which competition authorities around the globe may assess how a specific anti-competitive agreement or merger may affect healthcare quality. And essentially, these are the US market approach, under which competition authorities define quality in healthcare strictly as choice, competition, innovation. And this is a definition that they actually use also in other sectors of the economy, not only in healthcare. The second approach is the holistic approach, or else the European approach, under which competition authorities may actually extend the notion of consumer welfare in healthcare so that quality encompasses also the notions of equity, access, and acceptability. And third, the regulatory approach under which competition authorities may actually cooperate with health authorities when they assess the impact of a specific transaction in healthcare quality. So the market approach, or else the US approach, which is the approach that has been widely adopted by the US antitrust enforcers when they apply competition law in healthcare, actually reflects the central mantra of competition policy that the more the market players in the market, the higher the quality of the service they will offer. So to the US antitrust enforcers, rigorous competition among providers and not necessarily cooperation among them may lead to health improvements. Nonetheless, my book demonstrates that health services research and medical specialists often tell a completely different story. Specifically, they say that especially when hostile mergers are at stake and under standard conditions, collaboration among providers and not necessarily choice and competition may bring health improvements. For example, a merger increases patient volumes for hospital providers. In light of medical research showing a relationship between procedure volumes and patient volumes, the higher volumes a merger brings may in certain cases enhance the overall quality of the service provided by the merged entity. For instance, regarding pediatric quality of care, medical research shows that hospitals treating higher volume of patients with similar health conditions have better adjusted mortality rates. And this also applies for several surgical procedures. In addition, a recent study that was just published in a top medical journal shows that rural hospital mergers are associated with better mortality outcomes for specific health conditions such as heart failures and stroke. So in such cases, the challenging question that I think that emerges is whether the antitrust enforcers should allow the merger, although it may increase market power in the relevant market, on the basis that it may lead to quality improvements for rural residents, for example. So when examining these mergers, if the antitrust enforcers adopt a narrow definition of healthcare quality, a definition that essentially reflects the notion that rigorous competition among providers may always necessarily lead to quality improvements, they risk applying a merger analysis that is not necessarily in line with medical or health services research on how health improvements in hostile markets are actually attained.
Very interesting. Maybe just to get a little more specific, are there particular cases here in the United States that you think are good examples of the market approach, and how have the agencies and the courts sort of wrestled with or balanced healthcare quality arguments that the emerging parties or the providers in particular conduct cases try to advance as they look at evidence of potential harm to competition?
Yeah, so in my book, I try to analyze several mergers in Section 1 of the Sherman Act cases that reflect the US market approach. And the reason I do this is because I want to identify the pros and cons of this approach. So today, yes, I would like to focus on two antitrust cases that reflect the market approach, I think. The first one is a very famous antitrust case that we all know, the North Carolina State Board of the Dental Examiners. And the second one is the Teladoc versus Texas Medical Board antitrust case. So the first case, the North Carolina antitrust case, centered around the strategy of the Board of Dentists to prevent non-dentists from providing teeth whitening services in North Carolina. And of course, as we all know, and not surprisingly, the FTC initiated antitrust proceedings against the Board of Dentists on the basis that the board strategy restricted price and quality competition among dentists and non-dentists, and hence deprived consumers of affordable teeth whitening services. And in defending their strategy, the board emphasized, of course, that its actions were covered by the state action doctrine, an argument that was easily rejected by the enforcers in the court. But in North Carolina, the dental board also raised the claim that its strategy against non-dentists protected patient welfare by promoting public health. Specifically, the board said that if non-dentists were allowed to offer teeth whitening services, the quality of the other services, of teeth whitening services, would actually be undermined in North Carolina. And to substantiate their claim, the board had submitted reports indicating mainly three things. First, that several consumers suffering from adverse side effects, including bleeding, after receiving treatment by unqualified providers. Second, that several mall kiosks where teeth whitening services were offered by non-qualified providers lacked even access to running water. And third, that the board had received several complaints by consumers indicating that non-dentists offered teeth whitening services without meeting minimum quality and hygiene standards. And the FTC actually rejected these arguments in their entirety, claiming that in general, a public safety defense is actually extraneous to an antitrust analysis of anti-competitive effects, and that public safety considerations do not constitute a cognizable consideration under U.S. antitrust. The enforcers dismissed the board's health concerns. And this is because from the antitrust enforcer's perspective, competition will always necessarily lead not only to lower prices, but also to higher quality and safer services for consumers. An alternative analysis antitrust enforcers often claim would amount to nothing less than a frontal assault on the basic policy of the Sherman Act. And I would like also to mention another important case that reflects a U.S. market approach, which is the Teladoc versus Texas Medical Board antitrust case. And this case concerned the antitrust complaint filed by Teladoc, a telemedicine company, against the board over a rule that condemned prescription of any dangerous drug or controlled substance without first establishing and defined physician-patient relationship. And this included a physical examination that should be performed by either face-to-face visit or in-person evaluations elsewhere defined as requiring the provider and patient to be in the same physical location or medical state. And essentially, Teladoc, the plaintiff, said that the rule adopted by the Texas Medical Board restrained, of course, competition by reducing access and by reducing price competition and by constraining the overall supply of healthcare services. So, aiming to defend the challenge regulation against telemedicine, the Texas Medical Board in Teladoc also raised the claim that this regulation served a public safety purpose. The board alleged the regulation under scrutiny ensured public safety and healthcare quality. And in supporting the claim, the board cited testimonies submitted by physicians illustrating the limitations and weaknesses of a telephone-only diagnosis. According to the board, this testimony showed that patients may be harmed to the extent they receive care without any physical examination in person. The board also challenged Teladoc's argument that telemedicine significantly increases access to care for patients who cannot easily find healthcare providers. The board argued that the group of consumers who make use of telemedicine is actually a more affluent consumer group. And therefore, telemedicine might not necessarily increase access for the disadvantaged populations in the United States. Of course, the district court was not convinced on the basis that public safety concerns cannot enter the antitrust analysis. But what I wanted to emphasize and say is that in supporting the board's claims, the American Medical Association and the Texas Medical Association jointly filed a brief, and in this brief, they actually explained why public safety might be undermined if telemedicine remained unregulated. They actually recognize that telemedicine significantly benefits patients by increasing access to healthcare services, but at the same time, they highlighted that this form of treatment is inappropriate for certain medical conditions, and hence, sometimes they may even harm patients' health. So, in other words, the physician's word that there is information asymmetry when care is provided through telemedicine, and has a regulation under scrutiny did nothing less than correct this information asymmetry and ensure public health. So, can public health concerns such as these ones be considered under the US market approach? I think that the answer is a negative one. And this is because under the US market approach, rigorous competition, choice and variety ensure health outcomes from the antitrust perspective and not necessary collaboration among competitors or restraints to competition. So, what are the alternatives? I think that the US antitrust enforcers should widen their definition of healthcare quality. They should adapt a definition of quality that considers also the goals of access, equity, and acceptability, or else a notion of trust in the doctor-patient relationship. Because by adapting this wider definition, they would be able to balance healthcare quality concerns and public health concerns against the harm caused to competition.
That's very interesting. Thank you. It seems that the U.S. agencies have really come down in their work to date on this focus purely on competition and sort of volume and choice and variety rather than healthcare quality as you define it, with equity and access and improving the doctor-patient relationship. And maybe just to segue into a wrap-up question here, as a scholar who's got deep understanding of the health policy as well as antitrust and regulation, what are a couple of things that you think could be done in U.S. competition antitrust law to promote healthcare quality for U.S. Citizens and the population?
I think that the agency and the court should focus more on cases, especially mergers, that disproportionately affect the most vulnerable populations. For instance, in my work in progress article, The Healing Power of Antitrust, I observed that healthcare in rural America has actually hit a crisis point. Although rural communities experience worse health outcomes than urban communities, hospitals in rural America are closing at a dangerous rate, especially after they merge with another entity. So rural hospitals struggle to retain nurses and physicians who frequently abandon their rural communities to pursue employment opportunities in metropolitan areas. SAS hospitals also lack the financial resources they need to improve their infrastructure and update their medical technologies. And this leads also rural residents to bypass their local hospitals for more high-tech hospitals in affluent areas. Hospitals also in rural communities treat more patients who rely on Medicare and Medicaid or who lack insurance altogether, meaning that they go uncompensated or undercompensated for the care they offer, or at greater loss than do urban hospitals. And due to these factors, we see that rural hospitals are closing at a dangerous rate in the United States. Over the past 10 years, more than 100 hospitals in America have closed, and areas without access to hospitals and primary care physicians are called hospital deserts. And every state has at least one such healthcare desert county. But as hospital closures in rural America increase, hospital deserts in rural America also increase in size and number. And research demonstrates that hospital deserts reduce access to care for rural residents and increase health disparities in America. When a hospital shuts its doors, for example, rural residents must travel extremely long distances to receive care. Rural populations, however, tend to be vulnerable, and some residents may not even have access to a vehicle. So, not surprisingly, empirical research evidence indicates that rural residents often skip doctor appointments, delay care, or stop adhering to their treatment. My work, however, examines the problem of hospital deserts and hospital closures through the lenses of antitrust law. And by doing so, it demonstrates that hospital deserts are actually an antitrust problem, and hence they are not inevitable. And this is because many hospital deserts are the result of several business strategies hospitals in America employ that disproportionately harm rural Americans. And these include non-compete agreements in the healthcare sector, which restrict mobility for nurses and physicians and prevent physicians from offering their service to rural communities suffering from a shortage of healthcare professionals, and several hospital mergers that have increased consolidation in the hospital industry and have contributed to the hospital closure crisis that has harmed the health and wealth of millions of Americans. So despite this fact that this merger reduced access to care for the most vulnerable among us, they have received very limited attention by the antitrust enforcers. So I feel that the antitrust enforcers in the courts should confront the harm that hospital deserts or mergers among rural hospitals pose to rural Americans, because if they fail to do so, they risk applying antitrust law in a way that contributes to the rising racial and health inequities in America.
Well, thank you so much for going through your research with us and explaining the outcomes that you've come to in your book. We always transition now to a fun part of our show where we hear a little bit more about you. So what is something you could tell us about yourself that we wouldn't know if we only knew you in the professional world?
That I'm a first generation student. My parents did not have a college degree, but they understood very quickly that it's really important for them to, and for us, to invest in our education. So I will always be grateful for that. And I always share this story with my students. I always tell them that, I'm a first generation student. I don't have any lawyer or academic in my family. But despite all these challenges, despite the fact that I don't have an American degree, I don't have a JD degree, I managed to become a law professor in the United States. And I always like sharing this story with my students specifically, because I want them to believe that if you work hard and if you find amazing mentors in your journey, you will always manage to succeed your dreams. So this is something that I always want to share, especially with my students.
That's great. And thanks so much for sharing, that inspiration that you provide to your students, to your listeners. It's such an important thing, I think, especially in this profession, to reiterate that message. And now we will just do our last segment where we ask you a mystery question from our Curious Hat.
And now it's time for the Curious Hat.
All right, so choose a number from 1 to 10.
9.
All right. So if you could get free front row tickets for any show or festival in the world, what would it be?
Because of my recent passion about tennis, definitely go to Wimbledon Games.
That is
in London.
That is a very good answer. Well, thank you so much, and thank you for telling us so much about your research. And we look forward to seeing more, from you in the future. So we appreciated you having us on, and to our guests, see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.